The main issue in the case is whether Yeshiva University is subject to New York City's anti-discrimination law, which prohibits, among other things, discrimination on the basis of gender identity or sexual orientation. I guess put another way, it's whether Yeshiva University, as a Jewish university, is constitutionally entitled to an exemption from the anti-discrimination law, so that it doesn't have to recognize the application of some LGBTQ students for a gay pride club. The case, I think, turns on the meaning of general applicability, which is a vestige of Smith and Lukumi and the existing doctrinal structure. The basic doctrine is that there is no free exercise right to exemption from a law that is neutral and generally applicable. And so everything turns on the meaning of generally applicable. Some Supreme Court justices, US Supreme Court justices, and some commentators argue that if there is any exemption for any kind of secular behavior, then that renders the law not generally applicable and entitles believers to an exemption from a law that burdens their beliefs or practices. Other Supreme Court justices and other commentators argue that a law remains generally applicable so long as the secular activity that is exempted is not comparable to the religious activity that's exempted. That is, religions are being treated equally with secular activities so long as no secular activity that is comparable to religious activity is exempted. So the New York City anti-discrimination law is actually quite extensive. Over the years, the city has narrowed the exemptions that are available, and there are only three. For private clubs whose members do not do business with non-members, and for religious orders, and for what's called a religious corporation, which is a corporation formed for the purpose of providing a place of worship. If the court were to adopt the so-called most favored nation understanding of general applicability, then the very fact that there's any exemption would require an exemption for Yeshiva University as well. The strongest argument for Yeshiva would be that it's entitled to this most favored nation status, that religion is entitled to be treated the same way as any secular activity exempted from the law, regardless of whether the exempted activity has the same sort of impact on the city's interests in the law. That's pretty far out in the doctrinal weeds. I think actually that the court is not likely to decide this on narrow technical doctrinal grounds. I think it's more likely that it will expand. It will go further along the path that it has followed in recent years of expanding the reach of free exercise exemptions apart from the doctrinal structure that exists in that is set out by Employment Division versus Smith and the Church of Babalui Lukumi case. what happened in this case is that Yeshiva lost at the trial court level and was ordered to immediately recognize the gay pride group. At that point, it sought a stay in the order during its appeal, and the trial court and the New York appellate courts denied that stay, and so it appealed for a stay to the United States Supreme Court. And the Supreme Court denied that temporary relief, but 4 justices dissented, and those justices, I think, laid out pretty clearly the rationale for a ruling for Yeshiva on the merits. Their argument is that the trial court has essentially ordered Yeshiva University to follow the interpretation of the Torah offered by the gay pride students, the students applying for the club, and prohibited it from following its more conservative interpretation of Torah, and that is something that secular courts are absolutely prohibited, disabled from doing under the United States Constitution. So this is sort of an expansion of the internal affairs or the church autonomy doctrine, church autonomy cases that generally hold that a church is insulated from government interference into its internal affairs, who its leaders are, what its doctrine is, those sorts of things. So that's not a current doctrinal argument, because the effect of that order, that is the effect of exempting Yeshiva University, extends well beyond those who adhere to that particular interpretation of doctrine. Many employees, many faculty, many students at Yeshiva are either not modern Orthodox Jews, or they're not Jews at all. Yeshiva has a large number of individuals who don't adhere to the particular interpretation that the leaders of Yeshiva University have espoused in denying the gay pride application. And normally the internal affairs doctrine is restricted to affairs that are actually internal, that don't extend or have effects that fall outside of the religious group. And because of Yeshiva's openness, ironically, it would be a fairly dramatic expansion of that doctrine to hold it applicable in this case. But nevertheless, we have 4 Supreme Court justices who have indicated their attraction to that basis on which to decide the case, and they would need only 1 other justice in order to decide the case on that ground if it ever resurfaced or came back to the court. The best doctrinal argument is that is the one that I've recited, that the anti-discrimination law is generally applicable, and that under the current doctrinal structure, generally applicable laws, incidental burdens on religious activity from generally applicable laws are subject only to the lowest level of scrutiny, and there's clearly any number of rational bases for upholding the application of this law to Yeshiva University. I think also on the facts, Yeshiva has held itself out as a more secular university than it's claiming here. It has in the past in public relations releases and in representations to get funding, suggested that it is not as religious a place, not as Jewish a place as it is claiming now in this litigation. Gay pride groups exist, especially in its graduate professional programs like the law school. And so it's held itself out as more as an educational group that is granting secular degrees than as a religious group whose primary mission is to educate Jewish students in a particular interpretation or understanding of the Torah. And of course, it has a history of accommodating LGBTQ students. So even if the court were to abandon the doctrinal structure of Smith and Lukumi, there would be this trail of activities in which Yeshiva University has suggested, as a matter of self-interest or for whatever reason, that it is not, shall we say, really that Jewish. And therefore, it is not an interference with its religious group beliefs to require it to recognize the Gay Pride Club. It seems clear after the Fulton case, City of Philadelphia versus Fulton, that a majority of the court is ready to reconsider the current doctrinal structure, Employment Division versus Smith and Church of the Lukumi Babalui versus City of Hialeah. Those are both cases from the early 1990s, and the court has progressively narrowed the application of the doctrine in that case. Certainly the four dissenters, the four justices who dissented from the denial of temporary relief to Yeshiva from the trial court's order seem ready to do that and seem ready to expand the internal affairs doctrine to allow a religious group to allow it a true autonomy to structure its affairs however it likes in accordance with its religious beliefs, even if that structuring extends far beyond the bounds of its membership. In City of Fulton, it was that opinion was written by Chief Justice Roberts. He has the reputation of wanting to proceed incrementally and an aversion to overruling cases rather than narrowing them. But there is also Justice Kavanaugh, who doesn't seem to have that sort of aversion. And I think it's likely that either Chief Justice Roberts or more likely Justice Kavanaugh will join the four dissenters, and that would form a 5-person majority to expand the internal affairs doctrine. I think that would be a cataclysmic effect because it would not necessarily be restricted to churches or synagogues or mosques, and not even restricted to religiously affiliated universities like Yeshiva. But if we think back to the Hobby Lobby case, where the court found that someone can exercise religion through the vehicle of a for-profit public business corporation, a for-profit business corporation, closely held, not public, then that would dramatically expand the burdens that a religious group could impose on those who do not belong to the group.